Texas court rejects Hartford's spurious argument that a denied policyholder's lengthy and detailed appeal letter undermined her complaints of cognitive impairment. For those of you who live in Texas, you need to know that Texas has banned discretionary clauses. And as a result, when a beneficiary challenges a plan denial based on a factual determination of ineligibility, the reviewing court has to apply a de novo review of the factual and legal review. In other words, the court gets to use their own judgment. And that was a great for Pike in the case of Pike versus Hartford. Now, I read cases across the United States because I learned lots of lessons. And in this case, Pike was paid long-term benefits for over 8 years because of her severe back pain and degenerative disc disease. Under the terms of the Hartford policy, Pike had to demonstrate by a preponderance of the evidence that she couldn't perform one or more of the essential duties of any occupation for which she was qualified based on her education, training, and experience. So Pike provided medical evidence that she couldn't work the number of hours in a regularly scheduled work week, and Pike's claim was denied. Pike appealed, and Hartford argued that Miss Pike could not possibly be disabled from performing any occupation because she had written this lengthy and detailed letter to Hartford. The court was not impressed at all and awarded benefits to Miss Pike. Now, what was important about this case was the fact that writing a lengthy and detailed letter may have been a letter that she didn't write. It may have been written for someone or by someone at her direction. It might have been written over the course of a number of days or even weeks or months. The report may have been reviewed by a lawyer, and it might have been amended and fixed and corrected and rewritten. There was no information that was really garnered in this case about who wrote the appeal letter, and the court just wasn't impressed with the fact that a claim would be denied based on an appeal letter because it's a gotcha. If the person wrote a poor appeal letter, then the carrier could say, well, there just wasn't enough here. But if the policyholder wrote a great detailed appeal letter, which was really sufficient to overcome the claims denial, then the carrier could say, well, you couldn't possibly be disabled. You don't have the cognitive impairment. You couldn't sit long enough to write this letter. So the court said, hey, this is a gotcha situation. And we're going to reject opinions of physicians who just really aren't believable or credible in a situation like this. So the lessons learned are be careful when you write an appeal letter, particularly if you're claiming a cognitive issue. It can backfire against you. And in this situation, she was darn lucky that the judge was able to see through this claims denial, but not all judges are. So lesson learned is don't write a detailed appeal letter unless you make it clear that you're the person who's that someone other than you are writing it. 2, you're better off, quite frankly, to have a lawyer who's experienced in ERISA disability appeals to write that letter. And 3, don't count on the goodness of a court to overcome a wrongful claims denial because not every case has a de novo standard of review. In other words, for example, in Florida, we have the arbitrary and capricious standard of review, which means that it's very difficult for a judge to set aside a wrongful claims denial. They can't substitute their own judgment for that of the insurance company. So those are the 3 lessons that have been learned in this case. If you have any questions, contact me at 727-894-3188 for a complimentary consultation.